In February 2013, the Auditor General released his report on the Health Benefits Operations Alternative Service Delivery Contract. To read the full report, please visit www.bcauditor.com. The following presentation is a summary of the report. As the nonpartisan independent auditor of the Legislative Assembly, the Auditor General audits the government reporting entity. This consists of ministries, crown corporations, and other government organizations, such as universities, colleges, school districts, health authorities, and similar organizations that are controlled by or accountable to the provincial government. The Office of the Auditor General serves the people of British Columbia and their elected representatives by conducting independent audits and advising on how well government is managing its responsibilities and resources. Under the Auditor General Act, the Auditor General conducts and reports on both financial audits and performance or value for money audits. The Act also allows the Auditor General to follow up on any recommendations made in reports. In November 2004, the Ministry of Health signed a 10-year contract worth $324 million with Maximus BC Health Inc. and related companies to administer the province's medical services plan and pharmacare programs and improve related technology. These services are also known as health benefits operations. This contract was one of 11 alternative service delivery or ASD contracts signed by the province and was of particular public concern when it was signed due to the labor and privacy implications of outsourcing sensitive and critical services to the subsidiary of an American-owned company. The ministry expected that this ASD arrangement would achieve a number of benefits, ranging from the improved service levels to technical benefits like new technology and improved privacy and security. The benefits we examined were among the key benefits put forward to decision makers and announced to the public. The purpose of the audit was to determine whether the Ministry of Health has been monitoring and achieving the expected benefits of the health benefits operations arrangement, and publicly reporting on the costs and benefits of the arrangement on a regular basis. We focused on whether or not the benefits had been achieved and how effective of a role the ministry has been playing in assuring their achievement. Since we were concerned with the ministry's role, we did not conduct a direct audit of the service provider. Instead, we analyzed the ministry's performance information on the achievement of benefits. We also considered the validity and reliability of this information. We did not audit whether the benefits were the right benefits or whether corresponding improvements had the intended impact on operations. Overall, we found that the Health Benefits Operations ASD arrangement has resulted in some improvements, but the expected benefits have not been fully achieved. We concluded that the ministry's monitoring of the service provider can be improved. For example, in some cases, monitoring has occurred, but the ministry has not consistently held the service provider accountable for its achievements. Also, most of the performance information monitored by the ministry is provided by the service provider. In circumstances where this information is key to demonstrating the achievement of benefits or mitigating significant risks, the ministry should obtain assurance that it is accurate and reliable. Further, the ministry has engaged third-party auditors to gain assurance over many aspects of the performance information received from the service provider. However, the scope of this assurance does not cover all of the key attributes of the reported information. We also concluded that the ministry's public reporting on the arrangement does not cover all benefits, and costs are not reported alongside results. More transparent public reporting on the costs and benefits of the arrangement is required so that the public can understand what has been achieved for what cost. Where service levels are concerned, service provider reports indicate that all service level requirements outlined in the contract have been met since November 2005, and at least 6 have improved since the handover. Nevertheless, we were unable to conclude whether services have improved for 2 reasons. 1, the ministry has not been obtaining the required level of assurance over the accuracy of the data underlying reported service level results. And 2, baseline data does not exist for more than half of all service levels. As a result, the ministry cannot be certain reported results are both accurate and higher than pre-handover levels. As for the transformation of legacy systems, call center technology, the MSP claims system, and the registration and premium billing systems were supposed to be replaced by April 2006. Only the call center was replaced on schedule. The MSP claims system was completed in 2012, 6 years later than expected. The registration and premium billing system has only been partially replaced and may not be completed before the end of the contract in 2015. Delays were caused by both the service provider and the ministry. After 2006, it became clear to the service provider and the ministry that the service provider's technical solution for 2 of the 3 major systems was not viable. Some later delays were caused by ministry-led initiatives such as the Revenue Management System and the BC Services Card. As the ministry did not formally monitor the IT currency benefit until 2011, we were unable to determine whether IT currency requirements have been met for the most of the contract term. However, we did note that the replacement of desktop and laptop computers and Pharmanet hardware updates were delayed beyond the timeframe established in the contract. We found that the ministry has been largely effective in transferring the financial risk to the service provider. However, we did note that the ministry paid an additional $13.6 million to the service provider for operations covered in the current contract. Of this, $11.6 million was the outcome of a dispute resolved under the dispute resolution terms of the contract and was significantly lower than the initial claim made by the service provider. Because of the ambiguity of key contract terms such as material change and material impact, we were unable to determine whether an additional $8 million was also for services included in the contract. We also noted that the ministry does not have a documented set of criteria for assessing proposed changes to the contract and does not keep a comprehensive record of proposed changes and the rationale for the decision whether or not to implement them. Most of the privacy and security benefits identified by the ministry have been implemented, including numerous structural and technical safeguards and policies and procedures. However, there are some significant gaps in the ministry's monitoring of privacy and security under this arrangement. 2 tools intended to proactively identify breaches were not implemented, and third-party audits commissioned by the ministry do not cover subcontractors. They also do not provide assurance that the data access and storage are limited to Canada and that data access is segregated from the service provider's parent companies as promised. As a result, the ministry was unable to demonstrate that these key outcomes intended to mitigate the risk of disclosure under the U.S. Patriot Act have been achieved. As for profit sharing, the ministry is not monitoring the service provider's audited financial information to identify profit sharing opportunities. As well, the ministry's public reporting is limited and does not cover all expected benefits of the arrangement. Quarterly reports issued by Health Insurance BC focus on service levels and leave out key benefits such as the transformation of legacy systems, privacy and security, and risk transference. Further, the costs of the deal are reported separately in the ministry's annual report, making it difficult for readers to know what is being achieved for the reported costs. To address significant concerns identified in our audit, we recommend that government 1. Critically assess the viability of proposed solutions and plans to ensure that timelines are realistic and technological solutions will meet business objectives. 2. Ensure all key terms are defined in the contract and establish quantifiable thresholds where appropriate. 3. Monitor and enforce all significant contract terms and deadlines. 4. Obtain assurance over the accuracy of significant results. 5. Maintain a comprehensive record of decisions to facilitate knowledge transfer and consistent decision-making over the life of the contract. 6. Publicly report results by contract objective with sufficient information to enable readers to understand what is being achieved for what cost. We will follow up on the status of the implementation of these recommendations and provide our findings in our Spring 2014 follow-up report. Given the significant use of contractors to deliver provincial government services, the Office plans to conduct additional work in this important area of government expenditures. That concludes our summary of this report. To read this report and other publications, or for more information about our office, please visit our website at www.bcauditor.com. The Office of the Auditor General encourages your feedback on this report as well as your suggestions for future audits. We look forward to hearing from you.